to mention land motion, my lord, which was in the list, my lord. But due to change,
Motions, please hand over the slip.
yes,
Upgradation, please hand over the slip indicating the urgency.
my lord, another, my lord, cooperative hearing, my lord, that was in the list of,
Hearing, please don't mention. Motions, please hand over the slip.
my lord, that was in the list, my lord.
Hearing, please.
Very urgent.
Maybe. Hearing, please
My lord.
wait.
My lord, may I be permitted to mention one matter? This is a writ petition which I'm mentioning upon notice to my other side. My lord, only for extension of the interim order.
Please hand over the slip. Indicate when it is expiring.
It is expiring on 31st.
Please indicate the date.
Regarding item number 94, Lordship,
Yes.
previous days, Lordship, the matter was listed under the heading of fixed motion, Lordship. On 6th January, your Lordship was
94.
Yes, Lordship, under the heading of fixed motion.
Yes.
Tender matter, Lordship.
Yes.
The matter is wrongly listed, and in the ordering portion, I am I follows that the heading is fixed as motion, Lordship.
Yes.
Instead of fixed motion.
Fixed motion, I do not have any group of fixed motions.
Lordship, earlier occasion, Lordship, your Lordship also directed to appear under the same heading on 3rd December.
Same heading, but I do not have any group of fixed motion.
Lordship,
Please motion is motion, no fixed motion.
the matter could not reach, Lordship. Then, Lordship,
Please wait for a week.
Lordship, the tender matter, Lordship, on 3rd December, Lordship, the matter was listed under the heading of
please mention in the next week if it is not reached in the course of this week. If it is not reached in course of this week, please mention in the next week.
Then I have to mention the urgency, and your Lordship kindly update.
You don't need to mention, madam. I'm asking you, please wait for this week. If it does not reach, please mention in the next week.
My lord,
Can you not wait for 2 days? Can you not wait for 2 days?
Yes, Lord.
Under compelling circumstances, I'm seeking leave to file this writ petition and move it tomorrow. The election of the cooperative society is on 25th, my lord. The urgency that has cropped up, my lord, despite there being a model code of conduct, all the people are making camps within 200 meters.
All right,
Can it, and my lord, can it be tomorrow, my lord?
please serve a notice, because
I will serve the writ petition on them.
there was a request made that cooperative matters will be taken up only on Tuesdays. Accordingly,
My lord, I know, my lord, but I would not have troubled your lordship if the election is not on Sunday, my lord.
have trouble because it was a request from the bar.
My lord, I shall serve notice. I shall serve the writ petition.
They have to move before the tribunals and other things. Only one.
I shall serve writ petition, everything.
Yes.
But can it be tomorrow, my lord?
Yes.
My lord, may I be permitted to mention item number 175 of the monthly list, my lord, for upgradation, my lord.
Please hand over the slip indicating the
Matter for inclusion in the list motion.
Please hand over. I have said inclusion, upgradation. Please hand over the slip.
My lord, one application for restoration not passed by your lordship, my lord, it has been passed by your division bench comprising of your lordship as well as with Honorable Justice Om Prakash Rai, my lord. My lord, what has happened? Om Narayan Rai, my lord. Sorry. Om Narayan Rai, my lord. On that day, we are for the applicant that was.
Restoration যেদিন ওই জাস্টিস রায়ের সঙ্গে একটু কথা বলে নেবেন কবে হয়। হ্যাঁ, অরিজিনাল সাইট নিয়ে নিন, দিয়ে দেবেন অরিজিনাল। ইয়েস,
Judgment. You upload yesterday.
এইটা নয়, কালকে বোধহয় 2, 3, 4 and 5 যেটা ছিল না, কালকে লিস্টে তুমি মেনশন, তার মধ্যে এই জাজমেন্টটা দিয়ে দাও। ইয়েস, থ্যাংক ইউ মিস্টার রায়। ইয়েস, ফর দ্য লিস্ট। ডাকুন।
My lord, I am being for correction of order sheet. My name is Sudip Chatterjee, State Advocate. Transcribed as Sudip Chatterjee.
What is the correction?
Name, my lord.
Oh. It has this matter was directed to appear under the heading to be mentioned. Yes, Mr.
First, I want to render unqualified apology. I left early yesterday.
I asked you to appear Because no one is appearing for the railways. Can you appear for the railways?
Yes, I can. If my lord so
He told that nobody is the central government advocate has refused to accept the service.
that cannot be, because Ministry of Law is there. And normally what happens, Lordship, that I have
Because this was served, nobody appeared. Thereafter, I directed him to serve. He said, notice they are refusing to accept.
my lord, in that
why
case,
I,
case, my lord, will kindly may record an order, my lord, because recording me, and with one of my juniors, my lord, that may be done. But my lord, one, because it has fallen from your lordships, the problem which I will have in taking instruction is that if my lord kindly takes up the brief of the matter once, my lord, this is with regard to land losers. And I have already communicated with the concerned officers of the railways. And then after that, I read the brief myself, because I had, well, there is a provision under the Amendment Act of 2008 of Railways, where Section 20 specifically denotes what will be the procedure. My lord, will kindly have a look at this act, this
Yes.
excerpt of this act.
It-
Now, my lord,
Now, who is the authority?
my lord, now, my lord, what I am humbly,
Section 20.
yes, my lord, will kindly see.
Yes.
Now, my lord, they have in the entire writ petition, nothing has been mentioned as to when the publication was made for acquisition, whether they have given any objection under 20D. And even if when 20D, if they have not given and they have accepted that particular acquisition, what has been the fate of 20F, that is determination of amount payable for compensation? There is a earmark procedure.
No, he's not, Mr. Trivedi, he is not challenging that.
My lord,
Only
I'm
he
saying-
wants his name to be recorded under the land
Lord,
loser category.
my lord, I need to have certain cogent information from the writ petition.
So that
If my
can
lord
be-
kindly sees, he is asking, my lord will kindly see what he is asking is, if my lord kindly takes up the third, page 4, paragraph 3.
Page 4, paragraph 3. Yes.
He is saying he was in peaceful possession of the aforesaid plot of land. The respondent authorities by notification as published in which notification where published?
So you have to give some
Sunday-
particulars.
what I will
Otherwise, how they can
Lordship-
take instructions.
Lordship, 2011 notification has
Please,
been, he
please
does
give the
know every
particulars. You have
detail.
not
Then my lord will,
everything is vague.
then my lord will kindly
That is
see.
why I made a representation before the authority concerned. Land has been acquired. He will
But you
hold
have
an
to,
inquiry
Mr.
to pass
Mishro,
the region order. On that
My lord
ground,
will kindly see the representation at page.
representation to pass the region order.
Dada,
He is the
Amran-
competent authority. So many orders have been passed by this, so many courts, Lordship. I have obtained it.
My lord-
Representation would be considered, will take an appropriate action by holding an inquiry. Without holding an inquiry, opportunity hearing would be held. He will reveal the records as to whether it has been acquired or not.
I am trying to help.
It was acquired, Mr. Mishro.
It has been
that-
acquired, Lordship. That would it
Under
has-
what proceedings? When? Nothing. Everything is vague. You have to give some specific particulars. On such a vague petition, no order can be
My
passed.
lord,
Lordship,
because it will
is
not
not,
help this.
Lordship, that this is not the vague order, Lordship, the vague petition. Lordship, it has been acquired. It is an admitted
When
fact.
Mr.
2010 notification has been introduced, Lordship.
File a supplementary
Supplementary, yes, my lord, that was
affidavit
one.
that, in 2010,
Yes.
it was acquired.
Acquired
Please,
and
everything is vague. You have also not said 2010. Please file a supplementary
And my
affidavit.
lord,
that
even if the
2010
representation is considered, my lord, we will not be lacking particulars.
Mr.
And it is
Mishro,
huge
it's not
number
a
of people.
question of directing them. I can pass a direction, directing them to consider. They will say, no particulars has been disposed of, we cannot do anything. It's for your client's benefit.
I'm grateful, my lord.
He's saying only for your client's benefit.
I'm
that you have to
grateful, my lord.
understand. Please give the particulars when it was acquired. Some particulars are necessary. Otherwise, how do they know?
দাদা এইটা দেখুন 20 একটা ডিটারমিনেশন যদি না হয় এক বছরের মধ্যে,
Was notified in area in
Thing-
question in the Nondigram.
Please give that particulars.
Exactly.
When? Say something. Otherwise, how they can
Lord.
take instructions? Please understand their difficulty also.
notice must have been served on them.
Yes.
So my lord,
have
some
been-
referral
you
points.
must have got compensation. That's not your grievance also, that you have not got the compensation.
I have not got compensation and land loser. That he does know
You have
everything,
not got
Lordship.
compensation.
Lordship.
So when it was acquired, please file a supplementary
Yes, my lord,
affidavit
that-
giving the particulars when it was acquired.
Because, my lord, otherwise, my lord, it will be neither here, because my lord will kindly take up 20F.
Consider this also.
My lord will kindly take up
Effective,
20.
Mr. Mishran,
Lordship,
effective
I have
order has to be
understood,
passed.
Lordship, the entire record is lying of the authority concerned. So many matters he had disposed of it.
Mr. Mishra, I'm giving you a simple example. If you say I have filed a writ petition, please enlist that in the list. Can it be done? Unless you give some particulars.
Lordship, I will collect the notification.
This
The
is a
lot
simple
area in
example which I
question.
can give it to you.
Lordship,
Nobody is denying that you have filed a writ
Lordship,
petition,
Lordship,
but you have to give some particulars.
Lordship, I will collect the area in question that it was notified.
Yes,
Lordship,
please.
So that notification I have to find out, Lordship.
Please give some number, date, year, something, which plots along with this. Otherwise, how they can search this?
Any document যেটা এই acquisition এর সম্বন্ধে পেয়েছে ওরা ভদ্রলোক, তাহলে আমার একটা নাম্বার
If you have
রেফারেন্স
said,
নাম্বার
yes, you have not received compensation, then we can also direct them to
Yes,
take instructions
yes,
what happened. Affidavit of
As I'm moving on an urgent basis, my lord, that
তুমি মুভ কালকের ডেটে দিয়ে দিন, আর্জেন্সি আছে তো।
grateful lordship. I apologize for troubling your
To
lordship.
move tomorrow.
Grateful lordship.
Yes. Yes. Call the next matter.
Lordship, I am for the petitioner, Lordship. The service has not been completed, Lordship. I am praying for 1 week accommodation. Lordship.
Since the service, since the writ petition has not yet been served upon the respondents, the The hearing of the writ petition stands adjourned. First of list is yes,
I am for the petition. Okay.
yes.
Right. Petitioner is my father was a refugee, and which will be clear from the page 41. Malad, government directed me, allotted me 2 plots. One
Page 41.
page 41, Malad.
Yes.
Allotted me 2 plots and directed me to deposit rupees 20 rupees and 9 rupees for 2 plots. One residential and another commercial. I have deposited my father. I have not known my father, who already died, Malad, and in the meantime, Malad, that slip is missing. And Malad, but
Deposit slip is missing.
that father deposited.
Yes.
We are not getting it. And when what happened, my lord, we are ready to deposit it, maybe, but it is the plot has been recorded in our name.
Recorded in your name.
Yeah, but that is
Now what
now the
what do you want now?
my lord, further there's a dispute about the recording and as such, my lord. We made filed a writ application and writ application directed to consider me.
Withdrawn
This is at
cancel the
40
order
page
dated
41.
19th of September. Where is
Yes.
the order dated 19th of September 2025? Where is that?
My lord, this is that page 52. Page 36, there is a Honorable High Court order. And my lord, order dated, that is
19th of September is at page 52. Please give me a
page
minute.
52 is the final order.
Yes.
Well, it cannot, I think, well, it cannot be decided without the affidavit, I think. There is a Bazar committee and they will decide, and they have not affected me, but my petition has been rejected. Decision at page 55.
Still we are in possession. We are running business.
I were in possession and were running business there. And I'm staying in the residential plot.
Business is on.
So you have given a liberty to apply for grant of lease of the Colony Bazar lands.
According
But
to me,
because-
want from the government. So let it.
Maybe that you have deposited
Mala.
the amount, but you have lost the receipt.
Receipt.
But no lease deed has been executed.
Yes, that
So
is.
if no lease deed has been executed, this was sometimes in the year
1969. 1969.
So till date you sat tight over the matter.
No,
So
no,
what
Mala,
can be done now?
Let the affidavit file, Mala, do.
Affidavits, how it can be improved, sir?
Mala,
This is the decision. They cannot take a different stand. They cannot improve their stand by way of an affidavit. This is the stand. You don't have any document in support of your case.
We can, Mala, if they wants, Mala, that has been 20 rupees and 9 rupees.
Maybe
Now
accepted.
where?
Even if I accept, Mr. Chakraborty, your submission that you have deposited that amount. So thereafter, they were required to execute a lease deed. Lease deed has still date not been executed.
Mala, losses kindly come to page 41,
Yes,
where
40.
they have said I am refugee, and the land was allotted to me.
Show me the lease deed.
My losses can page 41.
Yes.
Page 41.
Yes.
And government said, well, it is.
Yes.
District Rehabilitation Officer.
Yes. Which portion you are trying to?
This is Rajendra Sarkar, father of the petitioner, Sapan Sarkar.
Yes.
Came to India from East Pakistan, now Bangladesh, as displaced person and took shelter in Joygatha GS colony at Sagda Moja, post Sagda Disimoja, as a bona fide refugee.
Subsequently, deceased Rajendra Sarkar got freehold title deed for being bearing number such and such in respect of the LOP covering 8 acres, 0.08 acres, Mouja Sagda PS Ato, district Noida corresponding to the plot number Ato for homestead purpose. There exists a little marker which is shown as a LOP map without any LOP number. Within this market plot covering about 0.4 acres more or less is lying under the possession of the petitioner. At present, there is only two abandoned wheels of the husking mills lying in the said block. I have a husking mills, my lord, because that was dispute. And without any connection, construction, one meets of measuring 54 square feet also lying in the plot on the during this inquiry, the petitioner, most of the soap owners of the market and local representatives were present. In this connection, it may be informed there that the district RR office had directed the Rajendra Chandra Sarkar to deposit 20 rupees and 9.75 in.
So where is your freehold title deed? Bearing number 55 of dated 15th of September 2003. Where is your freehold title deed?
Well, that is, I have annexed that earlier page.
Page.
Title deed, that is, they have, that is something is missing from me. And losses kindly come to, this is my lord allotted to me. Page 28.
Page 28.
And they have agreed that it was allotted to me. Malala, page 40.
No, where is the freehold title deed of 2003? According to you, you have got a freehold title deed.
And therefore, Malala losses candidate, you have hereby requested to
Yes,
inform.
Mr. Bandyopadhyay, what
writing.
is your instruction?
There are two plots are allotted in favor of the petitioner in the year 1969. For one for my domestic purpose and for another for business. So far as the domestic purpose is concerned, freehold title deed has been issued.
That is not in dispute.
Not in dispute. Only they are praying for the business plot. That is why page 41 we have hold.
So this LOP number 101 is not in dispute.
No. Yes, this plot is not in dispute.
What
They
is
are
the
asking
disputed
for
plot?
the business plot.
I am running husking mill, that plot.
What is the number of the plot?
From page 41 it appears there is no plot number. May I read, my lord?
LP number 101.
No.
Cosmo CS plot number.
From middle Miller. On 11th of December 2024, during inquiry, the petitioner, most of the shop owner of the market and local district were present. In this connection, it may be informed here that district RR office had directed Sri Rajendra Chandra Sarkar to deposit rupees such and such in separate challan immediately towards prorate cost of the said market plot corresponding to CS plot number such and homestead LOP 101 corresponding to CS plot number such and such measuring 0.8 acres of land of Joygatha scheme for the purpose of commercial use of the said plot, vide memo number 1969. It was ordered in the said memo that the amount should be deposited in due course of time, but petitioner could not produce any treasury challan till date. The petitioner claimed that their father, deceased Rajendra Chandra Sarkar, installed a husking machine on this plot in his lifetime for commercial purpose, and all the present agreed with this fact. But subsequently, in terms of government norms, no freehold title deed can be issued against any market plot, commercial plot, which is used as commercial purpose. Only lease deed may be issued against market plot after fulfillment of criteria.
What is the criteria? Where is the memo dated 8th of January 1998?
That memo
has applied for commercial plot for lease deed.
Yes, so that has to be done in terms of 8th of January 1998. Where is that geo?
That is not right now. It's
Produce that geo.
But can you see page 56, their representation? They have after conducting hearing, after passing of the reason order, we have hold that they are allowed to get the lease deed. Now they have applied for lease deed in page 56 and 57. This is their application for lease.
Yes.
Therefore, can you direct the authority to consider this lease?
Can you consider after this rejection order?
But we have rejected, but we have allowed. Can you see the page 55 decision? In the light of the foregoing findings, the petitioners claim to the land measuring 0.4 decimal within Joygata scheme number 8, RR colony budget is hereby rejected. However, concerned parties may apply for granting of lease of the colony land.
Chakraborty, pursuant to that direction you have applied for, I am directing them to consider in terms of that.
That will suffice, my lord.
Because they have been, you have been given, that is what I pointed out to you, that you have been granted, why are you not applying? So he has pointed out he has applied. So I'm directing them to consider
We
this.
have already applied.
So I am directing them to consider in accordance with law.
Yes.
And we are ready to deposit the amount if
That
they
is
calculated.
what are the
As per
formalities
that
that they
calculation, I am
will say.
ready
That
to
can be done.
deposit. Yes.
Well, may I leave it?
And losses kindly also note that we are ready to deposit
Yes.
Madam, happening.
Yes.
Madam, happening for the respond number 1 to 3.
Yes. Yes. David of service.
Where should I?
Taken on record. Every service taken on record. Yes. My lord, private
Within-
respondents are there. My lord, yes.
No.
No private respondent.
that's it.
Yes. Private respondent, my lord. Yes. What is this matter? My lord, the matter is, my lord, within Tiljala PS, my lord, I am the owner of 2 plots of land within Dag number 2647 and 3775, my lord. Suddenly, my lord, I've seen that that part of the land has been acquired by KMDA. And it is, my lord, I mean, I didn't know previously, my lord, page number, my lord, 15 and page number 16 of the writ petition.
Yes,
my
have you
lord.
served the KMDA?
My lord, I have served the KMDA and I have served a legal notice through the advocate to the KMDA also.
Page 19.
Page 19, my lord. My lord, the present situation is,
Where is Mr. Talukdar? If there are any acquisition proceedings, you have a right to raise an objection there.
I
Raise an
didn't know that, my lord, even whether it is,
What is the stage of the acquisition now?
I don't know, my lord.
Yes.
Not your lordship, can we see his representation? I mean the legal notice. Page 20, paragraph 3.
Paragraph 3.
Paragraph 3, page 20 of his legal notice. That recently it has seen from the record that the owners of his plots are allowing that the Kolkata Metropolitan Development Authority is the recorded owner of the such land.
That's what I can
It
see,
has
my
to be
lord.
ascertained that who is the owner first. Have the land acquisition proceeding whether at all has been done or not?
Everything has been completed, sir. Where were you?
My lord,
It appears you are not there.
my lord,
You have left
can
the
see,
plot vacant.
my lord, I can see, my lord, I can see now that
Whether
as
any
an
requisition and
unauthorized
acquisition
occupier,
something
my
has
lord,
been done
I
or
will
not,
say
that
that
has not been
unauthorized
stated
occupier.
anywhere.
My lord, they are capturing the land under
Ask Mr.
KMDA.
Talukdar to come. I am keeping it at 12.
Yes, my lord. Much.
About a 11:50. Yes. Yes. Yes.
This is my affidavit of service. My lord, matter related to compensation. My lord, my land has been acquired. And my lord, the
National Highway.
my lord, page 20. That has been
Compensation, you are agreed by the quantum of compensation.
right. And subsequently remeasurement was done. I have made objection, received the money on the same day with objection, and subsequently remeasurement was done. And after remeasurement, my lord, the fresh sheet has been published wherein my compensation is amount of compensation is shown. That is at page, my lord, 26.
26, yes.
Serial number 32,
32,
my lord.
yes.
MD Yunis Khan and
50 lakhs and odd.
no,
52 lakhs.
50 lakh 2,000.
Right.
Not 52 lakhs.
Right.
50 lakh 2,000. Yes.
50 lakh 2,000. I have been given initially, that is
92 lakhs.
92 lakhs, and
Page 20, my lord.
Initially it was 92. It has
no. It would have been
revised.
double the amount. It would have been double the amount. 20 into 2. That is the my lord,
My lord, page
the
20,
calculation.
your lordship will see.
That should be the calculation.
yes.
It should be the double the amount.
What was the initial? The initial,
Initial,
was,
my lord, 92, page 20, my lord.
yes,
90,
92 lakh
20.
86,000.
Yes, my lord.
Yes.
He received that.
And it would be 1 crore.
Yes.
And
yes.
now, my
8
lord,
lakhs difference is 8 lakhs.
Yes. So now what is your grievance?
Well, grievances that should be paid. They have, this is their assessment.
Oh, that
The
your
rest of-
grievance is that the differential.
Yes.
my lord, not yet. Your lordship will see 26.
26.
Page 26, what my learned friend said.
Yes.
That money will be paid by the competent authority?
Yes.
Yes, yes.
Yes, my lord.
So competent authority, you are representing
Yes,
competent
my lord.
authority.
For that reason.
When it will be paid, Mr. Dey?
Within certain times, my lord, but money will be paid by the national highway.
You have to realize, yes, Mr.
Other council is appearing.
না এটা আমরা দিইনি
Oh, you are not representing National Highway?
Then your lordship will give some time, my lord, and directed the national highway will pay the amount in the meantime. We will pay the amount if your lordship desire the time fixed. My lord, we must, competent authority must pay the amount. As because there is noting, my lord, that no amount was paid to them, my lord.
Yes, the differential amount, the initial amount.
Yes, my
has
lord.
been paid.
Yes, my lord.
yes
Revised.
The prop
টাকা পেয়ে
Yes,
গেলে
yes.
তারপরে আবার কি করবো আবার আসবে
Yes, 7. Yes.
I am for the petition. The private respondents are enclose the PWD land. For this reason, my lord, the ingress and egress of the petitioner is totally, my lord, blocked.
You are for the
state.
You are
I'm for
state. Private respondent, have you served?
Yes, my lord. All sub, yes, my lord. My lord, only one, my lord, has, my lord, refused, or other, my lord, has been received.
Your Lordship, kindly page 50, this is page 50, Your Lordship.
50.
50.
The demarcation has not been met by the
Yes,
BL and
pending.
LRO till now. The respondent number 3, assistant engineer, who will take.
So request for land demarcation has been made.
But my lord,
So no steps have been taken thereafter. So I'm directing the demarcation to be made.
and my lord also,
The petitioner alleges
and my lord also.
Yes.
Yes, my lord. Due to service treatment.
Yes.
My lord, this is a land acquisition matter, my lord, regarding the award compensation under section 28A, my lord.
28?
A.
Capital A.
Consider.
My lord, we have filed within a time, my lord, but till date.
File application.
Yes, my lord.
Yes, Mr. Banerjee.
I find that it has, they say in the representation, it has been filed within time,
Yes, my lord.
but not all. Kindly keep
I'm
all
not-
points open.
Yes, yes.
Till date, my lord, no appeal was preferred, my lord, by the other party, my lord.
Judgment passed in which case?
Same under same notification, my lord. And
What
it
is the number of the case?
Reference is LA 19 of 2017 before the learned third ADJ, Barashat.
Barashat.
Where, which paragraph, Mr.
Annexure
Page
P1.
16 is the judgment, page 16.
Page 16.
Yes, my lord.
No, which paragraph they have stated of this order?
Petition.
Operating page in 26, my lord. 26.
So, has made an application for a certified copy. LA case number 19 of 2017. Additional district judge, third court.
Barashat, my lord.
Paragraph 9 and 10.
The petitioner claims to be the owner of, claims that his property, claims to be the owner, claims that his property being RS plot number 463 within Moja Rajendrapur jail number 10 under police station Noyati in the district of 24 Parganas North was acquired wide LA case number 4/19 of 2008-09. Full stop. The award was passed
Same thing.
Same. Mr. Banerjee, you are appearing.
Service
You are appearing.
I'm for the state leader,
Everywhere,
Mr. Ghalib Lordship.
The date is same.
Hey, yes, my lord.
Judgment.
Yeah, same. All of same, my
Plot
lord.
number.
Plot number is different, my lord.
Different.
463 and 465.
আচ্ছা প্লট নাম্বারটাই শুধু লিখে নিন
Different.
463 and
হ্যাঁ,
465
হ্যাঁ।
মৌজা same
Mojo same. Under same notification, same
others
procedure, my
will
lord.
be same
Same, my lord.
28A
Submitting the 28A, my lord, that is date is different. That is
28A টা সাবমিট করেছে
28
28th of
December.
2022 and representation
Same, my lord. Same date.
same date
হ্যাঁ,
First,
representation
First
is 1st
March.
of March demand of justice is 1st of March 2024 disposed of same order next
Lordship laid by Mr. Ghalib Lordship.
Bremen.
led by Mr. Galib yes next
Appearing on behalf of the petitioner.
yes
Hello, sir. In this petition, my lord, allegations under section 10 of the West Bengal Highway Act,
yes
1964.
encroachment
Yes,
yes
my
Mr.
lord.
Mahant.
My lord, already order has been passed by the, my lord, the authority.
Order has been passed.
Yes.
No, my lord, this is another repetition. My lord, that is telling the page 47 P4, that is.
No, page 49.
49.
49 and 50.
No, this is the
Yes,
rescind
yes.
order. This is in another matter.
Another. I'm encroaching annexing this document only for reason that the land was obtained by the roads. Only on that only. That
Yes,
was-
Mr. Mahant.
Yes, my lord.
I'm directing you to consider
My lord.
to make necessary inquiries and to take steps in accordance with.
My lord.
Ashun. The petitioner claims to be the Yes.
May it please your lordship.
Yes.
Lord, this is my affidavit service, my lord. No private respondent is there, all government respondents.
Yes.
My lord, the grievance of the writ petitioner is that, my lord, non-accepting, my lord, the royalty, my lord, for my lord running the brick field, my lord, which he has been running, my lord, for a quite long time, my lord, since 2007, my lord, or onwards, my lord. And that too, my lord, in terms of a decree, judgment and decree passed by the learned civil code, my lord, on the basis of which, my lord, agreement was also entered into, my lord, that I have annexed, my lord, that, my lord, as page number 22, my lord.
Yes.
And that, my lord, lease expires, my lord, in 2037, my lord, till 2037, my lord.
Yes.
My lord, I have, my lord, paid the royalty, my lord, and I have also, my lord, complied with all the terms and conditions, my lord, for the purpose of, my lord, paying all the receipts I have annexed, my lord, till 2025, my lord, all the, my lord, the royalty, my lord, that have been paid, my lord. Now, my lord, there is a system, my lord, that we are to pay the royalty, my lord, in online, my lord. My lord, that, my lord, code number was given, and I applied for online.
Portal has been blocked.
My lord, that is blocked. Without assigning any reason, I have given
I
a
have
reminder,
not
two reminders, my lord,
instruction
no
from the
response.
proper authority, but I have got instruction from the police. There are seven.
Police is
Seven
neither.
Police has got
case for
no,
violation
no,
under
no, no,
the
no, no, no.
minerals rules.
My lord, no, my lord, that
No,
that
police is
cannot.
not the authority.
Police
Mr.
cannot.
My lord, I will take instruction from the.
My lord,
I
police cannot
submitted
do anything.
that I have not got
But
the
I have
instruction
also.
from the proper authority.
But I also show, my lord, that has got nothing to do with the police, my lord. Even a criminal case was filed, my lord, that has been quashed by the Honorable High Court, my lord, making some observation which may be
there
assisted
is
to your
an
lordship.
Nothing can be done. The proper authority is the block land and land
Yes, my lord.
reforms officer.
Yes.
My lord.
So he has made a representation, consider that and dispose of that because he has
Within certain time limits, my lord,
yes,
because, my
within
lord,
certain time
jurisdiction
limit.
has been assigned.
All these
And, my
cases
lord,
have
that, my
been
lord,
initiated at the instance of the VLR. All
maybe.
these cases.
Maybe.
Consider the petitioner claims to be running a brick field under the name and style. Where is that? That is why instead of BLRO, I have asked.
Yes.
District magistrate is not the authority for this.
District magistrate is the head of the.
Maybe the head of the administration, all matters cannot be dealt with the head of the administration. Yes.
Madam, for the petition.
Yes, yes.
Application under section 10(1) of the PW land.
In one, what happened? Any order has been passed?
No, no order has been passed.
You are for
application
the
is
private
pending.
respondent.
No, my lord, for the state, my lord.
State. You are for the
State.
state. Private respondent served.
Sir, madam. The two private respondents have served.
Because in APD service filed in court today is taken on record. Sorry, 3 minutes late. I asked you to come at 10:50. 11:50. Yes.
My lord, I am the owner of some other plots of land which are adjacent to this land also.
Yes,
my lord.
Mr. Talukdar, what is your instruction?
My lord, we have not, perhaps,
Served.
have not been served.
Service.
কিভাবে সার্ভিস করেছে?
আমি
Speed
service,
post.
হ্যাঁ, post.
Speed post.
Affidavit of service আছে।
Special Secretary, Land Acquisition. I have not received that. We've asked.
You have received, your client has received, Mr. Talukdar.
That's that right.
Yes, please take instructions because his
Yes.
allegation is that it has been recorded in your name. If it has been recorded in your name, whether by way of acquisition, after acquisition, or you are the owner, please take instructions.
Yes, yes, certainly.
Allegation is that his property has been acquired. He doesn't know anything. Consequently, no compensation he has received. Those follow.
That's the problem. This acquisition, Kosba Moza, took place, my lord knows, in 68, 69.
Much earlier.
And latest 76, 77. What
The large chunk was in 68,
68, 69. And the later part 76, 77. And 78, 78. Last.
Later part of 70s.
Subsequently, now the practice is going on. Some, my lord, I should not utter that particular word. They are my lord, collecting the plots, collecting the names of the erstwhile owner, and making out a
CS
case.
record. CS record
And-
because these are
and-
the added areas. So they are collecting the CS record of rights.
And-
From there. They are saying these transfers have been made, and
At the assi-
suddenly I've come to know that
at
such
the
and such-
assistance of some kind officials.
then coming for complaint. That is officials, Mr. Talukdar, belong to your department and his department.
We cannot. Yes.
Both of you are instrumental in this.
Yes. That's the problem.
Agent government and the government KMK.
That is why
And
both of
90%
your clients are instrumental in this.
That is why that principles of law the court should, my lord, we always insist upon. This is the only my lord, check.
Mr. Talukdar, there are two ways of looking at it. Because yes, you are right. In some cases, they are taking advantage of this. But in other cases also, you
Yes,
will appreciate
in some
highly
cases.
deserving cases.
That's true. That's true. That we
There
cannot.
may be certain things they are living outside, they have a property. You can take over, but by due process of there. Two ways of looking at it. One thing,
In both ways that we
and
cannot.
being the
But-
authority, being the custodian of records,
But-
you must
but
be having.
While we holding the brief on behalf of our client, my lord, we cannot avoid our responsibility. That's the problem.
Yes, please take instructions. When
Yes,
can you
yes.
come back?
Fix it in the next week. I'll be coming.
The petitioner
Perhaps Mr. Talukdar will revoke before Justice Subra Ghosh. ওই ম্যাটারটা মনে আছে তো?
Oh,
Similar type of matter. Same prayer, same type of things.
all right.
2 decimal of land.
petitioner led by Mr. Shomu Majumdar. But we'll kindly take up 96 first, my writ petition.
Yes.
96 led by Mr.
Yes.
Well, very briefly, the matter. Very briefly, the matter, my lord. Yes, lordship. The property in question is in Salt Lake area. Initially, it was leased out to a couple who, during their lifetime, executed. Yes. Am I audible, my lord? During their lifetime, they executed a last will and testament by which 1/3 and specifically the ground floor was given to one of the daughters, and the first and second floor was given to the other daughter. Probate was to the other daughter, Ruma and Jhuma.
3 daughters.
No, 2 daughters. One daughter, Ruma, who is my predecessor in interest, she was given the ground
1/3.
floor.
The
1/3
ground floor.
with the ground floor specifically mentioned. And Jhuma, who is the other daughter and petitioner in one of the matters here, she was given the first and the second floor under the said will. Now, the daughters applied for probate. Probate was granted by the learned trial court, and thereafter they mutated their names. Thereafter, what happened? The ground floor lessee, that is Ruma Bhattacharji, she approached us. We wanted the leasehold right to be assigned to us. Thereafter, a deed was executed by which the leasehold right with respect to 1/3 share was transferred in our favor, and the ground floor possession was handed over to us. Once it was handed over to us, we applied for trade license. We got ourselves enlisted, got a trade license and other licenses that are involved, and we started a restaurant business from the ground floor of the said premises.
If I may just interrupt my learned friend, below 27281.
Is my writ petition, my
But
lord.
there, my lord, the affidavits are not complete.
27281.
281.
Item 96.
That's 96.
Yes,
This is where
they are writ petition.
yes, this is they are tagged. But here, my lord, there was no direction for affidavits. We haven't used affidavits here.
Yes. Your writ petition will be there.
No, there's
affidavit
a very
opposition.
different thing here. They've brought up a very different thing here, my lord, in this writ petition.
Let me hear that.
My lord.
Yes.
A deed of assignment was thereafter executed, and based on that, I took possession of the entire ground floor. Thereafter, I obtained my trade license, and I will show the relevant provision as well, my lord. After obtaining trade license, also obtaining my food license, whatever is required, we started a restaurant business in the name of
Show
Chai
me
Break.
the initial lease deed.
Yes, kindly takes up my writ petition then, my lord. My writ petition, which is WPA number 27281.
Yes.
The main clause that they are focusing on, this starts from page number 28 of my writ petition. Kindly takes page 28 of my writ petition. This is where the main parent lease deed starts. Now, I am focusing or highlighting mainly on one.
me a minute.
Yes, I'm
Please give
sorry.
me a
I'm
minute.
sorry.
Yes. So after that, where is the deed
Senior
of?
is here. My senior is here, my lord.
Let Mr. Banerjee take rest for some time. He's running from somewhere else. Yes. Where is the next
Kindly
deed of
comes,
assignment?
kindly first comes to page 32.
Yes, 32.
32.
Yes.
The first subclause, this is
the lease deed, parent lease deed.
really allows me to place one relevant clause from the lease deed, from the parent lease deed. Which
Clause
is
number
at
10.
10. Just once,
Seen
may,
that.
may I just place it once?
Yes.
Not to use or allow, so in the negative tone. No permission, not to use or allowed to be used the land and or the structure thereon or any part thereof for any purpose other than for residential purpose without prior permission in writing of the government or other authority, I stress on other authority, prescribed in that behalf. Now this is a negative in from the very beginning, not to. Now why I focus on this, I'll show from my notification. Now lordship wanted to see my deed of assignment. Kindly comes to page number 45. Kindly comes to page 45. Kindly comes to page 45. Page 45 of my writ petition.
Yes.
Yes. Now lordship will kindly take up the notification on which the private respondents in my writ petition and the petitioner in their particular writ petition are relying on. Kindly takes page 82 of my writ petition.
Yes.
May I just first place the entire portion? It was in the active consideration of the government for some time for inclusion of a few more permissible categories of business activities of non-residential nature in residential buildings within the Salt Lake City in context of notification number such and such dated 22nd August 2014. This notification also we have obtained. It's part of my application as well. I'll place it later on. After careful consideration of the matter, the governor has now been pleased to decide that in supersession of the order earlier issued in this regard, wide notification number such and such dated 22nd August 2014, permission for non-residential use only up to 45% of total floor area of the building would be allowed to the lessee or lessees also for the enlisted subject categories following the terms and condition. So if lordship will place the clause that I placed earlier, that was clause 10, which started with it will, they cannot at all altogether, this has now yielded into this particular notification where the word would has been used.
Yes.
It has subsumed into this particular, it has now yielded into this particular notification earlier which was you cannot, it is now stating it is now, and my humble submission is that it is now incumbent upon the government or the respondent concerned to give me that permission, because the word would is being used over here subject to the factors that I comply with these particular conditions. So it is not that I cannot use it any longer, and it is now in my humble submission and
The
understanding.
prayer in the writ petition.
Writ petition is to quash and set aside the show cause notice, because the show cause notice was issued upon me asking me to show cause as to why I started a commercial activity, and also not directing the respondent authorities to not insist upon prior permission from the co-lessee, which is another issue that they have raised in their writ petition, that because the co-lessee is not giving me permission, they will not give me permission. I had made my application, my lord, but they keep on rejecting my application because the co-lessee is not giving her a permission. And on that score also we have submissions is that the permission of the co-lessee is not at all envisaged, contemplated in the said notification. It was earlier also not there in the application format which was earlier prescribed, although now they have included it. That the same thing has also been challenged in our writ petition as well. Yes. So it was not in the notification, but it was incorporated later.
Trying to supplement her. But the government at one point of time thought that Salt Lake should only be for residential purpose. But for persons residing in an area, there are certain other requirements. So from 2010 onwards, certain classes of activities or not operation was allowed in the Salt Lake area. But this your lordship will be pleased to find from the supplementary affidavit that I have used in connection with the in my writ petition.
Supplementary affidavit.
The notification of the government. Oh, I'm sorry.
Notification you will understand as placed. Any other notification?
Due to supplementary.
Supplementary affidavit you have filed.
And the previous notifications, I was paying
supplementary.
No, it was not filed. I'm sorry.
Have you given a copy to them?
Served.
Served.
আরে
ঠিক আছে না পরে কি কি করা যায়
না তুমি হচ্ছে মেন
Now, I draw your lordship's kind attention to the first notification at page 7.
7 of the
supplementary affidavit. Normally, this is done by the municipal authorities. Normally, it was in the active consideration of the government for some time for allowing non-residential use of residential buildings within Salt Lake City. Earlier notifications of relaxation for non-residential use of residential buildings were used for IT and ITES and also for opening of bank branches or ATMs. After careful consideration of the matter, the governor has now been pleased to decide that in modification of...
Do not fall within this notification because that was only for, according to you, the government was from time to time taking a decision departing from the original stand that it will be only for residential purpose.
I'm not to dwell.
This 2010 may not help you.
No, I was just trying to show the flow of events. So please see the nature of activities, school, banks, magazines, boutique shop, all these things. Then please see the 2014 notification, since the 2015 one has a reference to the 2014 notification at page 5.
Yes. Now page 5.
Yes.
Yes.
After careful consideration, but same language. The permission for non-residential use only up to 45% of the total floor area of residential buildings would be allowed. Would be allowed.
Yes.
Not would is normally used in the place of will for the purpose of making a statement.
Directory or mandatory?
Now, I'm not
so according to you, this is a mandate.
And what the nature of activities which your lordships will be pleased to find from the notification, these are normally found in the municipal laws. Say KMC Act or not the Municipal Corporation Act. What is the nature of business for which certificate of enlistment or trade license would be issued? In KMC area, there is a list of say probably 150 or something like that. Now, government took upon itself the duty to see that the residents can live in a manner which is in line with a normal standard of living. In that aspect, not restaurant and also lawyers' chambers, doctors' clinic were brought in the same notification.
Mr. Mojumdar, are you keeping the lawyer's chamber and a restaurant in the same bracket?
No, they have kept the government.
No, I am asking.
I am not. As an officer of court, I am not.
Please don't forever keep it in the same bracket.
No, what can be done? The state legislature has thought it not only for this purpose, but also for the West Bengal Shops and Establishments Act. What can be done?
Because lawyer's chamber is safe from
Commercial
profit.
Lord, that judgment of our court still protects us.
So that is why, please.
Now I'm not trying.
Respect to GST also.
Yes, I'm not trying to.
Many statutes, so please do not.
No, trying to sidetrack that judgment. Sometimes in 2014 or 15, the government brought it within the definition of commercial establishment, a lawyer's chamber. How could it be done? Now, be that as it may, now the question arises as to what is the effect of this notification. It really subsumes clause 10 of the lease deed. Because this is a policy decision taken in the name of governor in exercise of powers under Article 162. And this will have an overriding effect or obviously subsume that clause of the agreement. Because once again, if you please come to the clauses of this agreement, of this notification, the lessees will have to obtain prior permission from the Urban Development Department acting on behalf of lessor. So the urban development is acting on behalf of lessor in terms of clause 29 and 210 of the lease deed executed for leasehold right. But she has already placed what was clause 29 and 210. Please, I'm only traveling lordship with clause 29 once again and 210.
Yes, your learned friend has placed.
Yes. In case of a lease in favor of two or more individual lessees jointly, any one of such joint lessees will have the right to transfer his or her share to the other co-sharer or co-sharers. This is not applicable in our case. 10. Not to use or allowed to be used.
You are affected by 10.
10.
10 affects you.
Now, reference to 10 after the notification of 2014, if those have to be harmoniously read or juxtaposed, then not the 2014 or 2015 notification must have to be read to have an overriding effect.
According to you, automatically this gets superimposed in clause 10.
My lord.
Mr. Mojumdar, a hypothetical situation. Lessee is the original owner.
My lord.
Or the original lessee has constructed a 3-storied house, as in your case. Lives behind 3 heirs. So equally divided, let us not talk about those will and probate. 3 floors. Each they have mutually made an understanding who will. Now, how do you interpret this clause in the notification of the restriction of 45% of the total area?
Total area of the premises.
So each of them, whether they can utilize 45% of their entire of each floor, or it has to be the total building floor area.
It has to be understood in the context of the municipal building rules.
No,
has to be, otherwise it will lead to an absurdity.
What will be the effect? Each will have 45%, or together building 45%.
Not is my learned friend's client not trying to have a share of 45%
No.
on the ground? So that's not the case.
Whether you have a right.
Not that, Mr.
Right.
Mr. Mojumdar. This I'm trying to. What is the effect of this paragraph of 2014 circular supplementary affidavit? It says the permission for non-residential use only up to 45% of the total floor area of residential building.
Right.
Please answer me on the hypothetical situation which I have presented to you,
no, I'm not
the facts of this case. So 3 heirs are each occupying 3 floors. So whether this 45% would be the total area of the 3 floors, let us give you an example. 1,000 square feet each. So 3,000. So whether it would be 45% of 3,000 or 45% of 1,000 each in all.
It can't be 45% of 1,000 because FAR is in relation to a building and not in relation to a floor.
So it will be the entire building.
Now,
so it would be 45% of 3,000.
Yes.
Now, if 3 heirs jointly want, yes, all of us will use it. For non-residential, 45%. What will happen?
Can't exceed 45% of 3,000.
Yes. No. Then how can it be decided? Who will have how much share?
And that's between the parties.
If the parties are at loggerheads. If the parties are at loggerheads.
No, not so far as
let us take
proceed further,
Correct.
parties are at loggerheads.
Now,
Though
not-
they are the heirs
so-
of the original
So there
lessee.
was a provision for taking no objection from the co-sharer. Now, the Honorable Supreme Court has laid down that for the purpose of obtaining the municipal license, the no objection from the co-sharer is not required.
That's a different thing, Mr.
But the purposes are entirely different.
Mr. Mujumdar. Those no objection in the trade license issuance of certificate of enlistment are with regard to if a tenant or the lessees or licensees, whatever name called, they do not require no objection, as well as in the Electricity Act, occupier, because the statute gives the right to an occupier. So the landlord may not be the owner or the landlord, whatever name you call it, may not be required, or his no objection may not be required. But in the light of this clause, this particular clause which says there is a restriction, it's not that the entirety.
45%.
45% of the total floor area, how this is to be construed. Now,
Suppose there is a 3,000 square feet floor area.
Because I have heard from your learned friend's submission initially whether there were two objections. One is consent from the other co-owners or co-sharers, whatever.
But today, we probably have to restrict ourselves to the materials on record and not the ground of rejection and not the ground of objection even.
Ground of objection is one thing. Your learned friend has said that your application is not being accepted or returned, whatever may. One of the reason is that it was
permission for change of user is not taken.
That is one. Other is no. That was returned or not accepted because
please take the document.
Consent of the co-sharer of the other owner was not there.
No, that's in the form. That's in the application form. That one has to take permission from the co-sharer.
All right. So it was not returned on that ground. So where is the ground of rejection?
Now please come to page 97.
Yes. Yes.
Whereas by a deed of indenture executed between the governor of the state of West Bengal and Sri so-and-so, a plot of land being numbered so-and-so has been leased out to Sri Lahirian.
The parent lease deed.
Yes. And whereas the delivery of possession of the aforesaid plot was taken over by Sri Bishwas and Lahiri. And whereas presently you have been considered mutated lessee of the said plot through mutation order number so-and-so. And whereas in terms of clause 210 of the aforesaid indenture of indenture, the lessee, you are not entitled to use or allowed to be used the aforesaid land or structure thereon or any part thereof for any purpose other than the residential purpose without the prior permission in writing of the government.
Yes.
And whereas it has been reported to the government that the building erected on the aforesaid land is being used for non-residential purpose, namely chai break, in the ground floor of the building on the instant plot without prior permission of the government. In reference to present notification number so-and-so of 28th April 2015, it has also been reported that hookah bar is also running inside the building, which is not permissible category at all. So, two grounds. One is no objection from the government is not obtained, and number one, this is not a permissible category of business.
So now you are directed to only show cause. Why don't you reply to the show cause notice? Let them take a decision.
We have.
So what is the decision on that show cause?
First of all, there is a direction to close down. Now, on the basis of a report, there is a direction to close down.
I am directing them to decide this show cause within a time limit. Because Mr. Mujumdar, you have been asked to show cause. You have given a reply. So I am directing them to decide this.
May I submit this? The government has expressed it.
So I was under the impression that consent is not the ground. So ground is that you are using without any
no objection from the government, and this is not a permissible nature of use in terms of the notification of 2015.
Yes. So you can rely upon these notifications. What is the effect of that notifications? You'll be certainly relying upon.
Lordships normally do not interfere at the show cause notice because the ratio is it does not affect a right. But here my right has already been affected. Kindly direct reopening for 7 days and direct them to decide.
Mr. Mujumdar, I am directing them to decide it within 7 days.
But in the meantime, allow us to run. Because it has affected my right.
Can you decide this?
Not as your lordship desire. Not my lord.
Fix the date of hearing on 28.
May I submit this? For 7 days, the hookah bar will not operate. The restaurant will operate.
Mr.
No, it's a
Majumdar,
restaurant,
Mr.
it's a
Mo-
tea shop, tea
Mr.
shop.
Majumdar, I'm directing 28th hearing will be given, order to be communicated by 29th.
Not e-gate now, not we have a live demonstration, e-gate.
Mr.
E-gate of our court, not like that
Majumdar,
business.
The interim order is still February.
Right,
So I'm
I'm trying for modification of that.
Yes. I'm directing them to decide to fix the date of hearing on 28th of January, to communicate the order on 29th. How will we affect?
Pending.
4 days.
4
days.
4 days, Mr. Majumdar.
Not your lordship has seen the rush not at the e-gate now.
Because good, if you invite me, then some observations may come. They will take. That is why I've not yet made any observations on that. That is why you have been asked to show cause. You have given a reply. 28th, I'm directing them to hear out, or if possible, 27th earlier date. They can it be done? What is the earliest date which you can fix prior to 28th?
23rd to 26th is holiday.
That is why I've said 28th. Is any prior date possible? I'm asking you for that. 28th, I'm directing them to hear, to communicate by the end of January.
This instance I shall cite before a coordinate bench in another matter in a corporation case.
Which
Not e-gate, the e-gate instance. The e-gate instance, not the opening from 18.
We should not forget that this is not a heritage building.
We should not.
This is not a heritage building. Anything can be done.
That's Mr. Majumdar. That's in.
I'm not high.
Everybody should be given an opportunity of hearing.
Why? This is a government decision.
I'm directing. I do not know. I'm directing. They have issued a show cause notice. He has given a reply. It will be upon the authority to decide who has to move.
Because also to me as well. Me as well. To me as well.
You have been directed.
Yes. So all of us have.
You have been asked to show cause for what?
Same thing. Same.
You are also.
Because I am the
You have given a reply.
I have given a reply as well.
Then Mr. Majumdar, they have also been asked to show cause. They have given a reply. Both of them
independently,
or if it
there is nothing independent here.
Whether it overlaps, the issues may overlap.
I say, and he keeps his writs pending, sends it back to the.
Let us see the report. Not
Let the report.
What comes out?
What comes out? It can be
fresh cause of action, Mr. Chatterjee.
But it can be done here as well. We don't want to protract the litigation. Let it come to an end. Let the government decide. Give a report to your lordship. If it goes against me, I will file something. And if it goes against him, he will file something.
Mr. Chatterjee, Mr. Majumdar.
My writ is still there.
Both. The decision may affect both of you.
Yes, my lord.
May affect either of you.
My lord.
On ABCD grounds.
My lord.
So you have to challenge those.
Yes.
So this is a different.
Your lordship has sent it on a limited remand.
Has challenged the issuance of the show cause notice, and you have challenged something is being done by Mr. Majumdar's, allegedly done by Mr. Majumdar's client in violation of the lease deed. So what's the use of keeping this pending? You can very well file an application.
No, the lordship needs to send return a finding, my lord, on my writ petition. That they can't do it, my lord, without permission. My writ petition needs to be allowed.
They cannot do, Mr.
They cannot, without conversion, they can't do it.
One thing, Mr. Chatterjee, that's the show cause.
No.
Yes.
Because my writ petition is different.
Please see.
Show cause is yes.
His writ petition is for inaction.
Now, after the show cause is decided, nothing remains.
Yes.
So that is why let both these be disposed of. And that because they have
with respect
issued a
to
show
my
cause.
My writ petition, my lord.
Mr. Chatterjee, your writ petition was that
inaction.
certain things in violation of the lease deed.
He goes for inaction.
That's the ground on which the show cause notice was issued.
To them.
That yes.
And
to you also.
Me as
So that is
right.
post filing of your writ petition. And I think post first order, the first order passed in your writ petition.
Yes, my lord.
So these are subsequent.
May I say this, my lord? The cause of action in my writ petition is that, my lord, that they were using the premises without obtaining permission, my lord, for change of user.
That's 210.
That is 210.
210.
Now,
that's
your
the
lordship
ground in the
would,
show cause notice.
that's right, my lord. Now, my lord, your lordship would have to, my lord, in my respectful submission, would kindly dispose of that writ petition holding that they cannot.
Mr. Chatterjee, since that was in violation, now they have been.
Why is Mr. Banerjee laughing?
Between two Banerjees and Chatterjees, not I am the odd
both
one.
of you,
I don't
Mr.
know. I
Majumdar
didn't
and I am not a privy to that.
I am the odd one out here, not to Chatterjee, Banerjee, not I am out.
It wasn't funny at all. But anyways,
That's the ground, Mr. Chatterjee. The
yes,
of your
for show
is
cause.
is the ground
Yes,
indicated in the show cause.
My lord.
So now making any observation on your writ petition on that issue
Might affect that. That's
will affect
exactly
that.
why I'm saying.
That is why
That's
leaving those open.
Exactly why I'm praying.
I'm not making any observation since I will record that. Since that was your ground of challenge, now the show cause has been issued on for that alleged violation. That will be decided.
Exactly why I'm saying, Lord, keeps it pending.
Please have a look at the prayers, not probably.
Keeps it pending. Let a finding come on that.
Mr. Chatterjee, after the decision, you have to challenge that decision. So that will be a
And
separate
then
ground.
if your lordship disposes of my writ petition, then the interim order goes with it.
No. I will say till that show cause, this order will remain.
Yes.
Till the decision of
disposal
till the communication of the decision.
Very well.
Till the communication of the decision on the show cause. And I'm fixing the date. 28.
That is to be decided by
28. This hearing to be taken. Mr. How much time we will take to pass an order? Considering because it's also the life and
We have allowed that to party will go.
so communicate by the end of January.
Yes, my lord.
Hearing will take a little bit of time.
Hearing how much time, Mr. Chatterjee?
I don't know, my lord, but I having gone there, my lord, before the department.
If 28 not possible, cannot be concluded on the next day, you can. I will indicate that also. For some reason, the hearing cannot be completed on
Your
that
lordship
day.
knows not how long this hearing go on. 5 to 6 minutes at the most.
Mr.
I haven't.
All administrative. All
senior advocates.
nobody will. It's only an administrative hearing. Your lordship knows how it takes place.
No, I'm indicating that if not, I'm directing it on 28. If for some reason it can be completed within that, the next day it will be taken and order will be communicated with.
But I leave it to your lordship. Not kindly also appreciate not the predicament in which my client is.
The predicament where I am.
Why, Mr. Majumdar, I have requested Mr. De to
Lord,
fix
kindly
on
appreciates my
because
predicament
prior to
as well.
that, it will be a difficulty because this 4
Lord,
days
I
or
would
3 days.
request Mr. Banerjee in Mr. Banerjee's house. A restaurant comes in with a hookah bar with people staying in the house till 3 a.m. shouting. Let him not stay in that house like that. Let him stay.
But I'll request
Then
Mr.
his
Chatterjee
laugh
to take a
will
walk on
come on.
Southern Avenue and Mr. Pratap Chatterjee's that lane.
Why is it Salt Lake, Dada? Forget about Southern Avenue.
আচ্ছা ইনফোর্স না করে
Where are they being filed?
We have to file paper books. That will be compressed in an online mode. The page number will be changed. The index will have to be taken from the department of the court by the learned advocates for the respective parties.
So that is for paperless.
That's paperless court.
Paperless court, number one. Number two, this will deter people from the villages to come to court.
Mr. Chatterjee, there are two ways of looking at it
Yes,
because
but
nowadays you have to
Look, kindly sees the number of first appeals, sees the number of second appeals, sees the revisions. How many have been filed in 2025? Alarming.
to revisions. I was there for some part of 2025. Revisions,
90% are Miller expeditious hearing.
oh, I agree to that. Yes.
90% are that. Substantial revisions, Miller, it's gone down. Suits are not being filed. Where will the revisions come from? Writ petitions alarming. Again, 90% of that
Stateway half.
is police inaction, interest and gratuity, and
Just on gratuity now.
encroachment, police inaction.
It's 800 to 900 writ petitions on the original side per year, and 27,000 to 28,000 on the
We've seen
appellate
about
side.
a lakh every year. We've seen a lakh every year.
No, last year there was an increase from the previous year of the writ petitions. That
26,
year,
but yes, 26,000 to 27,000.
28.
29,000.
2025, there was some increase
29,000.
than 2024.
Again, 50% of that is political. কে কোথাও meeting করবে
Item number 110, 11, and 12, all are identical. Only the difference may be taken up analogously.
Yes, who is appearing for the state?
On last.
Yes, Mr. Dey. Yes, why are you leaving court? Yes.
Sorry, Lord.
Yes, you are appearing.
No, my lord, I am not appearing.
You are not appearing. Yes, what is this matter?
Under the petitioner's land was requisitioned under the Defense of India rules, under the Defense of India Act 1939. Subsequently, it was continued under Bengal Act. At the relevant point of time, 1951 Act, Continuation Act was applied. That was, but though requisition.
Order dated September 11, 2024 shall not be set aside. Where is that order?
September.
কোন ডিস্ট্রিক্ট গো? হাওড়া, পূর্ব বর্ধমান।
Oh no, Mr. Vivekananda Bose Tirthankar, they appeared. Where are they?
133, my lord.
Have you notified them prior to mentioning?
করেছো ওদের? নোটিশ করতে হবে।
You are mentioning for upgradation without notifying them. How do they know?
Kindly give me some time, also.
Yes, my lord.
The difficulty, it's minimum that is expected when you mention for upgradation, you have to notify the other side. Without notifying, you are mentioning for upgradation. This matter this sub notice thereafter mentioned. Minimum that is expected. Yes, call the next matter.
Matter number 14. এখন আর কেউ থাকবে না ডেলি লিস্ট
Malad, I appear for the National Highway Authority, Malad.
Who is for the petitioner?
Your Lordship, Mr. Ujjwal Roy is appearing on behalf of the.
Pass over next.
Number 15.